Welcome to this free immigration help channel. Today is April 10th, 2023, and we're getting into the volume 58 of me answering your immigration related questions in your comments. And actually today I have one email that I need to address. Before I begin, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information that I provide in my videos on this channel are directly from official government sources, USCIS, and of course the Department of State most of the times with their visa bulletin. So let's start with the email that I received. I'm going to read it, I'm going to answer it, and then I'll respond to that email with the number of the volume. The email is from Dimitru Rotary. Thank you for sending the email. By the way, whoever's watching, you guys don't have to send the email. It's much better to post your questions in the comments because as you can see they all appear here in front of me on the same wall, so I will definitely get it. I'm not going to miss it. I might take a little longer to get to it, but I'll definitely get to it. So the question is, I'm gonna read it. Good afternoon, Free Immigration Help Team. I'm asking for a little help. In my case, a little background. I have Romanian citizenship. Last year I got J1 visa, which is the exchange visitor visa, worker visa. Came here in 2022 USA and stayed over visa period, but I applied for I-539 and have status here. I got American driver's license, social security, etc. How can I stay and work here legally? Not marriage. Alright, I heard about E3 visa, but can I invest 100k made in US and get E3 visa? Money are made in US. And second one is employment sponsorship, which is crazy hard to get. Current situation, I'm on I-539 with tons and tons of hope to find a way to stay and work here. Can you please help me? Thank you, FIH team, Freedom Immigration Help. Dimitri, I appreciate your trust, obviously, with your question. So here are a few things that I'm gonna ask you to, if you can follow up, if you can post your comment in any of the videos, it doesn't matter. But I'm interested to hear what status you have currently. I'm assuming that you filed the I-539, you already said that. Did you change your J1 status to something else, or were you able to extend your J1 status? Okay. Another thing that I wanted to kind of go over what you said about the trader treaty, the investor treaty visas, the E1, E2, E3. Yes, some of them, they do not have the specified minimum investment requirement. Some of them, one of them, I believe it is E3. I'm not as experienced with the investor and the treaty visas in general, because the practice that I worked in and the cases that I dealt with were mostly family immigration and the asylum stuff. But I know that whenever it comes to the E in general, there is a category in there that does not specify at all a minimum requirement. Basically what it says is that, and I'm pretty sure it is E3 that you're referring to, you have to show the substantial amount basically of the trading that is happening between the country that is, so you have to be a national of a certain country, and I know there is a few Western, I'm not sure if Romania is under that treaty or not, but you have to be a national of a certain country and you have to show a substantial amount of trades that is happening, obviously because of you, between the country that is part of the treaty and the United States of America. So even if it doesn't specify the minimum requirement of investment per se, there is still a lot of stuff that you have to kind of show. So unless you are already involved into it, all right, unless you already have some kind of business that is happening, that you are already investing or already trading something, or you're building something, or you've been building up until today, it is pretty hard to establish this whole system, let's just call it that, just for the purposes of that visa, all right, the treaty trader or the treaty investor, whichever route you want to go with, because you do have to show all of these things. In fact, compared to finding an employer who is willing to sponsor you, whether it is non-immigrant visa or immigrant visa, employment visa, is actually much simpler. Why? Because all you have to do is you just have to show that you have the skills, that you have the knowledge in order to perform the tasks here in the United States of America that somebody else who is an American national cannot. So the employer is willingly sponsoring a foreign national in order, because they're the only ones who basically qualify for this position. And yes, it does sound like it's it's not an easy task, but at the same time, it might be more possible compared to a situation where you have absolutely nothing whenever it comes to the trades. I mean, I don't know your situation, it really depends. But if you don't have anything going at the moment, just building it up in order to get the visa, it's not an easy task. So if you can, post a comment with what status you have at the moment, because if you do have, the reason why I'm asking for that, I forgot to mention it, because if you do have currently a J1 again, so you had a J1, right? And you had that J1 extended successfully, which is not an easy task. It means that the employer that you're working with right now, because you're an exchange visitor, so you have the Social Security, you've been working here in the United States, it means that they like the work that you're doing, and potentially this is the same guys who can sponsor your non-immigrant work visa, or maybe even potentially immigrant visa if they like you that much. And for you to, there isn't much stuff that you need to do for that. It's mostly the employer that doing all the work. They filed the application with the Department of Labor. They filed the I think it's I-129 with the USCIS. They are doing all the work for you. So it's hard to find the employer, but it almost seems like you already have one. And that's one of the reasons why I kind of want you to concentrate a little bit on that as well. But I am waiting for your response in one of the comments in whatever video you can respond to this video. And I'll be happy to address it more and talk to you more about this. But I will respond to your email with the volume where I answered your question. And we're gonna move on to the next one. Now to the comments from Babar Ahmad. My brother has filed my case in 2017 and still is pending. How much time it take? Babar, unfortunately, I wish I could give you some better numbers and some better news. I really hope that you already know about the answers to this question, how long approximately it takes when you are in F4 category, forced priority category. That's when a US citizen is inviting brother and sister. And I can personally relate to that because I do myself have my little brother that I am waiting for. And unfortunately, judging by what we have right now from the visa bulletin, if we look at the priority dates for the F4 category right now, it's showing December 2007, which means there is about 16 years of backlog. So since your petition have been filed in 2017, you have been waiting already for, sorry, my math is absolutely horrible. That's why I deal with law and not with mathematics. 6 years. 6 years. So you have roughly about 10 more years to wait for that availability of that immigrant visa. Now, keep in mind, it's very, very rough because the visa bulletin for all of the categories except F2A, and this is actually for March. We're gonna go to April, the most recent one. I was comparing March and April yesterday in my yesterday's video. So you probably noticed in March the F2A was showing current. As of April 2023, which was the only update that we had in a long time, F2A that used to be current is now showing about 2.5 years of delay. So possibly we can add that 2.5 years delay, and I call it artificial backlog because it was caused during the closures, during the whole pandemic situation. You can add that 2.5 years for the rest of the categories that are not updated yet. So roughly 16 years plus another 2.5 years. You've been waiting already for 6 years, so 10 years plus that 2.5 years possibly of that artificial backlog. So we might be looking at 12 to 13 years more of a wait. And again, it feels good to me to share stuff like this, news like this, because this is not pleasant news. It's a long time to wait, and I don't agree with it. I think it's unfair. But I can personally relate. So we are in this together, okay? So Babar, I wish you some patience, and the only thing I can say is I really hope that this stuff starts moving faster, that something happens, some change, positive change happens, and these cases, the immigrant visa availability will become available faster for all of the categories. All right, let's move on to the next question from ES. I do have a question about part 1, information about you when I last arrived in the United States. After my asylum status was granted, I traveled to Europe with travel document. Okay, should I check 25D, other, and put asylee, or check 25A and write asylee there? Thank you for your video. Yes, thank you for asking your question. I'll actually use this as an opportunity to demonstrate some navigation on official USCIS.gov, US Citizenship and Immigration Services website. So we're gonna go into forms, and we're gonna go to all forms. And this question was asked on the form I-485. So we're gonna go to 485. You can either scroll down, this is all the forms, they're in numerical alphabetic order, or you can just type in the number of the form in the search, and there you go, application to register permanent resident or adjust status. Yes, by the way, congratulations on getting to this point. You had your asylum for 1 year, and now it's time to apply for permanent residence. It's the next step, and it feels good. All right, so we're gonna click on the form itself. We have them here in PDF. You can also find a lot of answers to questions with the application in the instructions, and I always recommend reading the whole instructions before filling out the form. But here's the form itself. Let's take a look. We're looking for part 1, information about you. So there it is. Here we go. And we are looking for 25. Let's see. We're going to scroll down to 25. There it is. Okay, so information about you. Person applying for lawful permanent residence. Continued. When I last arrived in the United States, I was inspected at a port of entry and admitted as, for example, exchange visitor, blah, 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 blah. Okay. Was inspected at a port of entry and paroled as, for example, humanitarian parole, Cuban parole, does not apply to us, no. Came into the United States without admission or parole, no, never mind, 25D, other. All right, so we have the 25A that is more or less applicable, was inspected at a port of entry and admitted as, exchange visitor, wave through, or other. Then for us it's going to be other because you already have granted asylum, so you can in other just type in granted asylum, and because you already arrived in the United States with an immigration status that was approved. All right, 25A is when the status is issued to you, and most of the times, as you can see, it's student, temporary worker, visitor, whatever, so it's most of the times non-immigrant status. 25B, it's a port of entry if it's paroled. So for example, if they give you example, a humanitarian parole, it's like, you know, if you come like as a refugee and stuff like this, that would be applicable. Came into the United States without admission or parole, obviously that does not apply to you at all. So yes, other, granted asylum, and that should be perfect for your situation. So let me pause this. If you have any more questions, do not hesitate to ask them. I am only happy to receive more questions. All right, let's move on to the next question from Dennis24. I'm sorry if I'm mispronouncing the name. My priority date is March 2017. How long will it take to be current, sir? Thank you. Dennis, thank you very much for your question. So I'm gonna ask you to please post a follow-up comment with your category. All right, that would be really helpful. But because you asked me a question on F1 versus F2B video that I've made, I'm assuming you are either in F1 or F2B, and both of the status, they only differ as of right now, as of April 2023 visa bulletin, they only differ by about roughly 6 months. Okay, so there isn't much difference. There isn't like a substantial difference between two categories to kind of you know, to say that this is or this is better. So we're gonna take a look at the visa bulletin, F1 and F2B. priority dates, obviously. So F2B we have January 2017, and then F1 we have August 2016. All right, so very, very close to each other. August, January, you have like 5 months, 6 months difference, right, between the two. Here's the thing, however, judging by this visa bulletin, April 2023, it looks like you should be already right now, immigrant visa should be available. However, unfortunately, because we had all the closures during the pandemic, that artificial backlog that I keep referring to, now we got information from the F2A with the most recent update that there is about 2 years, 2.5 years of that artificial backlog. So you might potentially wait unless something speeds up and they figure out the way to kind of clear out that artificial backlog that they created themselves faster. You're looking roughly at about 2.5 years more of wait time. But if you can provide a little bit more information, let me know your actual category. And also, you know what else would really be helpful? If you tell me whether you were already documentarily qualified or not. I am thinking you might already be documentarily qualified, because if you are already documentarily qualified, you meet all the requirements in order to send an expedited request to NVC. All right, because by judging by the visa bulletin, your immigrant visa should be already available, even though we know it's not because there is an artificial backlog. But nevertheless, this is the information directly from the government source, and it is showing that it should be available sometime right now. Okay, so if that's the case, if you're already documentarily qualified, you can send that request. It's not a guarantee that they will do it, but I recommend everyone to send that expedited request. Why? It might not do anything, and most likely it won't do anything for you specifically, but it will do for everyone as a whole, showing that, hey, you know, listen, your visa bulletin, your own visa bulletin, and I'm addressing the Department of State, right? Department of State, your own visa bulletin that you give us every month shows that my category, I'm supposed to have my immigrant visa already available, and yet nothing is happening. So the more of that kind of request they receive, and be professional, be polite. You know, I'm not saying demand anything, be professional, be polite, but nevertheless, according to this, it should already be available, and it's not. We know why it's not. Nevertheless, they either need to update this to show us the correct information, or they need to issue those immigrant visas. Okay, let's move on to the next one. From Sergey, Barcelona. Sergey, thank you for another comment. Really appreciate it. Hi, sir. I hope F1 will move on the coming months, and so as others. Actually, before I was in F2B category, mom's a permanent resident, then became a US citizen. Our attorney changed it to F1 category for final action date, and up to now I'm waiting for it to be current to 2013 August. Wow. I'm praying for all categories will be moving fast to be with our families as soon as possible. Thankful for your good heart, sir. More power to you and your channel. Sergey, I really appreciate your kind words. And, you know, it really does help when people in general, you know, immigrants that are going through this process, they're sharing their side of the story. Like, for example, you know, you hear this from Sergey. He's in F1. Right? He's dealing with the F1 family preference category, all right? First priority. Since 2013 August, that is, compared to the visa bulletin, that is like 3-4 years now behind. So Sergey should be, I mean, anywhere around the corner. I mean, I don't know how long that artificial backlog is for the rest of the categories, but it's almost scary, you know, because judging by F2A, we're like, okay, we got about 2.5 years, but then you hear actual experiences of people, and that's why it's really helpful. I think that is really the best benefit of this particular videos that I do, not because of me giving you some information, because all that information is publicly available. I'm just basically reading stuff from official government sources, all right? So I'm not doing anything much. What is really helpful is that you see actual cases of actual immigrants going through these things, and their dates and how long it takes, and you can kind of have some kind of judgment prediction about how long your case is going to take. Because it's one thing to just sit there in the dark, not knowing what's going on, especially with the visa bulletin the way it is. It hasn't been moving for so long for all of the categories, except finally F2A, just this month, April 2023. So I want to see the updated dates for everything else, but honestly, it's kind of scary. So Sergey, I really appreciate your kind words and your update. And yeah, I do pray as well, that not only we start finding out the real dates, but also that actually something happens and it starts finally moving, finally moving faster. Okay, let's move on to the next question comment from Fabrice Timo. Fabrice, appreciate you being publicly subscribed. Thank you very much. Thank you for this precious insight. I'm currently in the US on a student visa and can be petitioned for by my father in the F1 and my mother F2B categories because they are respectively citizen and permanent resident. Do you think it's safe to have both of them petition for me? How early will I be able to adjust my status as I currently live in the US with legal status? Okay. Is there a faster processing time for a service center to another? Thank you again for helping us better understand US immigration policy. Fabrice, you're very welcome. Thank you for asking your question, for your trust, in my answers, and that I not gonna tell you something that is, something bad. So really appreciate it. So let's start one by one. I'll start with the first question. Do you think it's safe to have both of them petition for me? Honestly, there is really no point of doing that. It's in a way, it's a waste of money because it's pretty much exactly the same thing. There is a difference, however, whenever it comes to whether you are filing as a US citizen or you're filing as a permanent resident, specifically in those categories, whenever it comes to the USCIS processing. And again, I'm going to use this as an opportunity to navigate, to show some navigation on US Citizenship and Immigration Services. We're going to go to Tools, and we're going to go to Case Status Online. And I know there's probably a faster way to get there, but this is just how I'm used to it. USCIS processing times. We're going to click on that, visit page. And we're going to go to Form I-130, Petition for Alien Relative. And then we're going to select, let's see, US citizen filing for, I'm assuming, well, if you are asking about the F1 versus F2B, then you are an unmarried son, 21 or older. All right. So we're going to do US citizen. This is for F1, and then there is permanent resident for unmarried son or daughter. This is F2B. So let's take a look at F1, and we just will do California Service Center for now, just to compare between the two. 76 months, 76 and a half, and I'll actually need my calculator because my math is just disastrous. Divided by 12. So about 6 years, about 6.5 years, all right, in California Service Center for US citizen. Let's take a look at the permanent resident and see if this is any different. And I'm gonna find out myself. 58 months. Wow, permanent resident is faster in California. Okay, so this 4.8 months. All right, so let's take a look at now Texas Service Center, which is another big, busy service center. We're gonna take a look at U.S. citizens filing for unmarried son and daughter 21. Texas. Let's take a look. 42 months, so 42 months divided by 12, roughly 3.5 years. And now we're gonna do permanent resident again in Texas. Get processing times, 40. All right, and that's 40 divided by 12, 3.3. So pretty much very similar. Okay, now I'm gonna do one more for the comparison, US citizen, and we're gonna click Nebraska Service Center. Let's take a look. 24 months, and that kind of answers the other question that you had about the difference between the service centers. As you can see, yes, absolutely, but don't let that if, for example, you live in if you will be filing to California Service Center, don't let that scare you too much. I will explain a lot of times why it's like this crazy times. So 2 years here, I don't need a calculator for that, thank goodness. Permanent resident, Nebraska, let's see, 34 months. More. All right. So Okay, let me do some explaining here. What's going on? Because this seems pretty crazy. It seems all over the place. Whenever it comes to the service centers, different service centers, they treat cases a little bit differently. Some service centers, they wait closer for the availability of the immigrant visa before they actually review the case, approve the case, and send the case to the NVC for further processing, for you to become documentarily qualified. Some of the service centers, like for example, it seems like Nebraska seems to be the case, they don't want to hold the case for too long. They just deal with it, they review it, approve it, and send it to NVC, and then NVC waits. And a lot of times you see people, I get a lot of questions. They're like, I'm documentarily qualified, but when I log into my NVC portal, I just have like a message like, hey, come back later, closer to the availability of your immigrant visa or whatever. So basically the NVC is now doing the waiting, closer to the availability of the immigrant visa. All in all, however, it all comes down to the dates that are showing in the visa bulletin. And you are F1, F2B. As of right now, as of April visa bulletin, like I was saying, it's about, between the two, it's very similar, it's just about 6 months difference. But as of right now, we have about 6 years, 6 to 7 years of the organic existing backlog that we had, without accounting for the artificial backlog that we accumulated during pandemic, which seems to be about 2.5 years, judging by the F2A, but judging by the experiences of other people, and I'm referring back to Sergey here, he has been waiting since 2013, which is roughly now about 10 years, which is another 3 years on top of the existing 6-7 years that you have to wait. So with all of that being said, instead of wondering too much what service center, this and that, which category, the best thing that you can do is just to file it as soon as possible. Which one do you think it's going to be easier for your dad or for your mom? Because both of the categories, it seems to be gamble. You can go with the F1 category and it might be processed faster than the F2B, and it might be processed slower than the F2B. And the same thing with the F2B. As of right now, unfortunately, it seems to be complete gamble. Keep in mind, F1, because it's US citizen filing, it's still a first priority category. Technically and statistically, for F1, there's still a little bit more immigrant visas that are available, but that doesn't mean anything, because it really, at the end of the day, depends on the amount of applications that are being received each year, because that's what determines the backlog, not the availability of, well, yes, a little bit on the availability immigrant visas, but that number is fixed. The number that is not fixed is the amount of applications that come in each year. And the very last question, is there a faster processing time from a service center? Yes, I already answered that. You already saw it for yourself. How early will I be able to adjust my status, as I currently live in the US with a legal status? Okay, so I think you said you were, let's take a look. Thank you for present, currently US on student visa. Okay, so you're currently on the student visa. So Fabrice, most likely, you know, if the petition has not been started yet, as of right now, we are looking at quite a long wait time, all right? That's why I recommend filing this petition as soon as possible, all right? Whether you decide to, you don't need to both parents file this petition, it makes no sense. Dad or mom, whoever is you think will be you know, because both of them, if they need a joint sponsor, for example, once your case gets to NVC, you don't even need to worry about the sponsor information as of right now. But let's say, for example, you know, if your dad is filing for you by himself, and then the case is transferred to the NVC, and they say, hey, no, dad needs more income to show, then you can just add your mom as a joint sponsor. Not a big deal, right? That's not the main concern here. One of the main concerns is that most likely, because, you know, maintaining that F1 status or just bouncing from one status to another non-immigrant status, you might have to deal with that, and that's not very, it's costly because every time you're extending, changing status, you have to pay the application fees. And obviously, a lot of times, especially if you don't have the kind of status here in the United States that allows you to legally work in the United States, it's really hard because you don't have any kind of income living here. So I would say that would be like one of your main concerns, actually working on either maintaining the status or finding a way to leaving the United States and coming back here, obviously, to reunite with your family and visit them, because it's a long time. It's a long time, and in most of the cases, the immigrants, the beneficiaries that are waiting, they don't have the opportunity to be here and spend time with their relatives, unfortunately. I honestly, if I know nobody from the government watches these videos, but if somebody does from the government watch this video, I think it would be a great idea to have a separate non-immigrant status. And the reason why I say non-immigrant, because currently it would be non-immigrant, with the further intention, obviously there is an intention to immigrate because there is already a petition, but it would be nice to have a whole separate visitor visa, non-immigrant visitor visa, for those relatives that already have the I-130 petitions filed for them, so that they can come here for a few months, just a few months, reunite with the family, spend some time with the family, and travel back and forth. If it's expensive, tickets are expensive, but if you can afford it, at least you have that opportunity to come here and spend some time with your family. And also potentially when the time does come to immigrate, you can come here to the United States knowing what it looks like, knowing what it feels like to live here, and not just coming to a brand new country, not knowing what's going on. So I think it would benefit everybody to have that. It would certainly benefit the families. It would certainly benefit the prospective immigrants to become better immigrants, because you come here and you already understand a lot of things, you already know a lot of things, you already seen, but now you have the immigrant status and you can work and you can do all of these things. So I think that would be a great idea. But Fabrice, I hope I was able to answer your question. If you have any follow-up questions, do not hesitate to follow up. Just don't respond to my comment. Within your comment, submit a separate comment, because the responses, for some reason, I don't get notifications for them. All right, let's address one more question for today, because we are already getting over 30 minutes, so I don't want this to be too long so people don't get too bored watching these videos. All right, a question from Muhammad Youssef. Sorry if I mispronounced the name. What about the National Benefit Center processing time? Okay, Mohammed, so whenever it comes to National Benefit Center, if you have a specific petition, it really comes down to what kind of petition it is. Sometimes there are some applications that they want to handle as soon as possible, and they promise you that they will handle it like within 30 days, within 60 days. Sometimes some applications, they are a little bit on delay. It might be because there's more applications for that particular, whatever it is, employment authorization document, adjustment of status, more volume of the application, so it takes more time for them to get to it. And sometimes, like for example, with when you're applying for employment authorization document based on, let's say, pending asylum, in those situations they promise like 30 days processing. So it really depends on what kind of application you have. Again, whenever it comes to processing times, anything that is with USCIS, unless it is in a specific field office only and is not with whether it is National Benefit Center or one of their like central electronic service centers, or Texas, California, Nebraska service centers, you can check the processing times using this tool right here. And again, official US Citizenship and Immigration Services government website, you go to tools, you go to case status, you can check your case status using the receipt number most of the times, and then check the case processing times. Also, one thing that I want to mention here as a kind of in the end that I haven't mentioned in this video is, if you see, this is 80% of cases, by the way, all right? So 34 months for 80% of the cases. So we still have 20% that take either longer or shorter. And most of the times, unfortunately, it's longer. But nevertheless, my recommendation is, if you see this 34 months and you have been already waiting for 40 months, 40 months over 34 months is a little bit of the 10% extra wait. And I recommend 10%, giving about 10%. So if your total wait time is 24 months, right? Processing time, that's 80%. You want to account for the 20% and give extra 10% over that time. So 24 months plus 2.4 months, all right? So wait extra 3 months over that 24 months, wait for 27 months total, and if still nothing happens, then go ahead and scroll down this page and click this link right here. Inquire about a case outside normal processing times. And this online form that you will have to fill out, it will allow you to submit an official inquiry, an official case inquiry. Most of the times, don't put too much hope into this. Again, most of the times the response is boilerplate and it's just like, oh yeah, we're actively reviewing your case. Great. So don't put too much hope into this. But again, this is not, it's more of not just for me personally, but it's for all of us, all right? The whole legal immigrant community, basically, everyone who's going through immigration process. Sending these online inquiries, showing the USCIS that, hey guys, you know, the stuff that you're showing on your website, those processing times, you either please update them, make them correct, or, you know, you please review my case, you know? And I say please, because be professional, be polite, but at the same time you let them know that your case been sitting there for a little bit too long. So thank you everyone for watching. Always appreciate your time. If you have any follow-up questions, do not hesitate to ask them, because without your questions these videos would not be possible. So I'm always happy to receive questions. Again, appreciate all your time, all your support, all your kind words, and God bless, and I'll see you in the next video.